Chairman, I reserve a point of order.
A point of order is reserved. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8227 offered by Mr. Buck of Colorado.
Without objection, the amendment will be considered as read. The gentleman has 5 minutes to explain his amendment.
I thank the chair. Like my first amendment, Mr. Chairman, this is a clarifying amendment. We've heard concerns, particularly in the ranking member's opening statement, but from others also, that this bill could impact the ability of parties to enter into post-dispute NDAs. While I don't believe the bill as drafted would pose that problem in any way, I want to make it abundantly clear that post-dispute NDAs are not covered by this bill. My amendment also includes a clause to ensure nothing in the bill limits states' ability to legislate regarding post-dispute NDA provisions. And I, at this point, would recognize the gentleman from Rhode Island if he wants to enter into a call.
Yes, I thank the gentleman. I appreciate the concerns of my colleague. To be clear, the bill only prohibits the use of NDAs before a dispute arises, which is triggered by the filing of a lawsuit under a state, federal, or tribal law. Nothing in the bill prevents parties from voluntarily agreeing to a settlement that does not include an NDA. In other words, this bill is carefully tailored to prevent sexual predators who are rich and powerful from evading scrutiny for their misconduct by buying the silence of survivors. And this concern, as you know, is not theoretical. Harvey Weinstein paid the survivors of his horrific abuse hundreds of thousands of dollars to silence them. The settlements included strict NDAs that prevented survivors from making their experience public. These clauses were drawn broadly, preventing employees from speaking to anybody, friends, family, press, public, private, about the alleged behavior, but also about their time at Miramax, according to one of Mr. Weinstein's former associates. During our hearing, Tatiana Spotswood testified that her abuser, former Affinity CEO Zia Chisti, used confidentiality clauses in her employment contract to keep multiple instances of overt sexual harassment and violent assault hidden while Ms. Spotwood's allegations were arbitrated. She testified that as the CEO of the company, he had power over my life and career, and I was anxious not to insult him or make him mad. And while she received a settlement in arbitration, his lawyers offered to give her father $1 million in addition to her arbitration award to prevent the case from becoming public. She was only able to come before the Judiciary Committee about her employer's abusive behavior and make her story public after receiving a congressional subpoena compelling her testimony. So those are two clear recent examples that strongly caution against preventing survivors from coming forward before a lawsuit is filed. Having said that, if the gentleman is willing to withdraw his amendment, we will continue to work in a bipartisan way after the markup to address his underlying concern before the bill comes to the floor.
I thank the gentleman, and I reclaim my time. At this point, I'm not going to withdraw. I will allow, hopefully, more debate on this issue, and if we can strengthen this amendment in some way, I'd like to see that, and then I will consider withdrawing at that point. So I yield back, Mr. Chairman.
Gentleman yields back. Who else seeks recognition?
I do.
For what purpose does Mr. Gaetz seek recognition?
Move to strike last word.
Gentleman is recognized.
So there's a fundamental misunderstanding about the operation of the bill and the operation of the amendment. Mr. Jordan took the position that the bill bars certain pre-dispute non-disclosure agreements. And Mr. Cicilline just said that the bill does not do that. And the misunderstanding comes with when a dispute arises, that can occur before a lawsuit is filed. I've litigated a number of these cases in private practice, and it is a fiction to say that the dispute arises at the time that somebody goes down to the courthouse and files a pleading. That has never been the case in any one of these matters that I was involved in litigating, and in almost every circumstance I'm even aware of, there are pre-litigation demands. And what the legislation does currently, and majority staff agrees with this, the sponsors of the bill agree with this, that currently the way the bill is drafted, you are robbing victims the ability to enter into a non-disclosure agreement post-dispute, but pre the filing of a lawsuit. That is, we should all agree to that. That is what the effect of the bill is. Now, the reason the Buck Amendment, I think, resolves a lot of those concerns is that it clarifies that your dispute can occur, the event of harassment can occur, and that you still have the full complement of rights after this bill would become law that you do today, to enter into a non-disclosure agreement. I can't imagine the sponsor of this bill would want to go from a circumstance where today there's a window of time in this horrific series of events where someone could enter into a non-disclosure agreement and that we're taking that away from people. I don't think that's the case. So I support the Buck Amendment. I think the Buck Amendment would probably get a lot more people to support the underlying bill. And
Mr. Gaetz, would you
yeah,
just,
sure.
I'm trying to understand what your concern is. So if you have an individual who is a survivor of sexual harassment or sexual assault in the workplace who has not yet filed a claim and there is no NDA agreement, there is nothing in this bill that would, of course, prevent that survivor from settling a potential claim and saying, I will not sue you if you pay me X amount of money, et cetera. So there's that ability of the survivor to decide whether to disclose or not remains with the survivor.
but the ability to enter into a non-disclosure agreement.
Well, it wouldn't
is
be a
robbed
non-disclosure,
from the
it would be a
survivor.
settlement.
But the settlement agreement couldn't involve a non-disclosure agreement that would be operational.
And there is nothing in this legislation that would bar that.
I don't think that's the case, Mr. Cicilline. I think that if you look at the definitions
There's
on
nothing
page
in this
2,
legislation
section 3,
that
line
has,
13,
but
they
this
talk
is about a settle, in the example I just gave you, that's a settlement of a potential claim. There's nothing that would prevent the parties from agreeing not to discuss it once they've reached a settlement.
Mr. Cicilline, active harassment occurs. No lawsuit has been filed, but a demand has been made to resolve the dispute with money in exchange for a non-disclosure agreement. If this bill, in this form, were to become law, that would not be allowed. And I think that's what your colleague is sharing with you now.
Will the gentleman yield for question?
I'll yield to Mr. Goldman.
Yeah. When this says that with respect to a sexual assault dispute or sexual harassment dispute, no pre-dispute non-disclosure or pre-dispute non-disparagement clause. So when does the dispute begin?
See,
Does that begin when you actually notify the employer that that employer has sexually harassed you, or does it begin when the incident? I think this language is much too vague and probably should say something like before the incident giving rise to the dispute, because this is very vague and it's going to cause a lot of heartache.
I think Judge Gomer has rightfully isolated precisely the issue. And in many areas of law, the way we mark the incident is when the facts give rise to a claim, right? When a claim arises from the event. And so I think of when the dispute begins at the time of the offending conduct, not at the time of the filing of the lawsuit. And so, again, I believe there's a high probability that this legislation is going to become law in some form. And so we offer these suggestions, and I think the Buck Amendment is offered so that
The gentleman would yield for one more
achieves that
time.
objective.
Just to be clear, in the bill that is before the committee, that question that Mr. Gomet raised is answered in Section 3. The pre-dispute non-disclosure clause means a provision in a contract agreement agreed to before a lawsuit is filed. So that's the triggering mechanism. I think the problem with the amendment is if it included access to counsel so that the determination is made with consultation with counsel, I would have less concern about the abuse of that process.
I just feel like if we compare this experience to like the arbitration experience, the cake is not baked here. The way I feel like we were a lot further along in understanding.
Which is why I think
legislation.
we can work out Mr. Buck's concern if we have a little more time on this issue before it comes to the floor. But I think we basically agree, and I think it's just a question of sort of fine-tuning the language. And I've had the privilege of working with Mr. Buck on so many issues. I'm confident that we can resolve this one.
We'll try to keep an eye on him over here.
Gentleman's time has expired. Who seeks recognition? If no one else, then the question occurs on the amendment.
Mr. Chairman.
The amendment is withdrawn. Are there any further amendments to the amendment in the nature of a substitute?
Yes, Mr. Chairman, I have an amendment at the desk.
The gentleman will, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 8227, offered by Mr. Cicilline of Rhode
Without
Island.
objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This is a technical amendment that will insert language used in the definition of pre-dispute non-disclosure clause to Section 3.2, the definition of pre-dispute non-disparagement agreement. All this amendment will do is ensure that non-disparagement clauses, which can prevent survivors from making any negative statements about their abusers or employers, regardless of whether the statement is related to the nature of the dispute, are given the same treatment as NDAs under this law. So this is a technical amendment. I urge my colleagues to support this and yield back the balance of my time.
Gentleman yields back. Is there any discussion of this amendment? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. The ayes obviously have it. Are there any further amendments to the... Someone want to talk? I'm sorry, Mr. Gomer. We'll withdraw the vote. Mr. Gomer is recognized.
Thank, yes.
Oh, the amendment is agreed to.